Good afternoon, everyone. Thank you for joining us for today's online talk. We'll be starting shortly at 3 p.m., so stay tuned. For those of you who are already here, we thank you for your patience. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Common Property Disputes, Recovering or Defending Ownership Claims. I'm Amir Haris. I'm a pupil in Chambers with Mao and Kwai and Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and explain the work that we do. Mao and Kwai and Associates is a mid-sized law firm that was founded in 1985 by Dato' Mao and Kwai. Our able team today comprises 33 lawyers and a support team of 31 support staff. Dato' Ma himself is currently a consultant with the firm following his retirement from the Court of Appeal bench in 2015. Today, the firm continues its tradition of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, as well as a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, as seen here, which are supported by great talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. To give a bit of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event that you require specific legal advice for any matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now, allow me to introduce our speaker for today's talk. Our speaker today is Ms. Kirbasyini Chandran, who is a senior associate in our dispute resolution departments. She has a Bachelor of Laws from Cardiff University and a certificate in legal practice. Her areas of practice includes contractual and commercial disputes, strata management, personal injury, public liability, medical negligence, land reference proceedings, and employment law disputes. Here are our main talk points for today, which are: what is common property? Second, how to recover disputed common property. Third, key arguments and evidence. And finally, decided cases with mixed outcomes. We will then conclude the talk at the end with a Q&A session where we will address any questions you may have. So if you do have any questions, please type it in the chat and we will address them at the end of the talk. Now, allow me to pass the floor to Ms. Kirba to begin our talk for today.
Thank you, Amir, for the introduction. Good afternoon, everyone. It's a pleasure to have all of you here today, and I truly appreciate you taking the time to join us for what I hope will be an insightful session on common property disputes. Okay, let's get right into it. We will kick off the session by establishing a common understanding of the definitions of a parcel, an accessory parcel, and common property. Now, these definitions are crucial because they form the very bedrock of a common property dispute. Now, essentially, common property is often defined by exclusion, meaning it's everything that is not a parcel or an accessory parcel. We will start off with the definition of a parcel. Now, think of a parcel as an individual unit in a subdivided building or land. This is the part that's intended to be held under its own individual strata title. So it's your own private space, whether it's an apartment, a shop lot, or an office unit. Okay, next, we will look at what is an accessory parcel. It's basically a small area or a parcel which is designed to be an accessory to a main parcel. Common examples are sometimes car park bays and small storerooms and things like that comes with your unit. The key legal requirement here is that an accessory parcel must be used in conjunction with the main parcel. And everything else that is not a parcel or a common accessory parcel will become common property. Now, common property includes all parts of the building or land that are not comprised in any parcel or accessory parcel. It's the shared spaces such as the lobbies, corridors, lifts, facilities, driveways, and often sometimes car park areas as well. Now, ownership of common property is collectively vested in all the proprietors, usually through the management corporation. This means that everyone has the right to use and enjoy the common property. Okay, next we will look at how the statutes define common property. Now, under Section 4 of the Strata Titles Act, common property refers to areas within a strata development that are not part of any individual parcel or accessory parcel. This reinforces the definition by an exclusion concept that I had just explained earlier. Then we have Section 2 of the Strata Management Act, which builds on this definition. It defines common property as any part of the development that isn't part of any parcel or accessory parcel and is used or capable of being used by the occupiers of two or more parcels. This part is quite important because it brings in the element of shared use. So even if a space isn't labeled as common property, if it serves multiple units like a corridor or a service area, it may still fall within the definition of common property. And then the next, we have the definition under the BCPA. So before the SMA, we had the Building and Common Property Maintenance and Management Act 2007, or for short for BCPA. So while the BCPA has been repealed, it gave a more practical list of what was considered common property. And this included things like a staircase, lobbies, refuse areas, lifts, pipes, ducts, car parks, and even some landscape open space. Now, although the BCPA was repealed in 2015, these examples help illustrate the types of areas that are generally considered common property today. To make this a bit more tangible, for those of you who have units in strata development, this is a simplified example of how this classification might appear on a strata plan. So if you look at this white area, parcels, these are typically your individual units, clearly numbered. So in this example, you can see units 2, 3, 4. So these are the units which would be the parcels. And then you have the accessory parcels, and you'll see this marked with an A followed by a specific number, and they are tied to a main parcel. So here we have examples like A31, A32, and so on. So this could be specific storerooms or sometimes even car parks, aircon vent areas, things like that. And then whatever that is shaded in yellow, that is the common property. So that represents the shared spaces. Now in this example, if you can see, there would be the tandas, the tangga, the lift, corridor, and things like that. So the corridors, lift areas, toilets, and stairs. And these are the spaces that everyone uses and collectively uses and shares, right? So if we bring this down back to earth a bit, what does common property actually look like in your development? So if we start off with access control infrastructure, this could look like things like the guardhouse, the entrances, the boom gates, things that regulate the entries of residents. They could be common property. Then you have the means of circulation, such as the staircase, lift lobbies, fire escapes, and shared walkways. Then you also have the structural components of the buildings, such as the roofs, the beams, the columns, slabs, shared amenities, swimming pool, gyms, playground, barbecue areas, things that are again designed for communal use. And then finally, the infrastructure elements such as the pipes, the wires, the tanks, and the sewerage systems, right? So those are some common examples of common property that you may be able to identify in your own development. Okay, so now that we have more or less established what defines a parcel, accessory parcel, and gone through some examples of common property, the big question is always what happens when these definitions are blurred. Then when they are blurred, then of course it comes to how do you recover, or sometimes defense against the recovery of these common properties. So whether you're trying to reclaim what you believe is common property or you're defending an area that is being claimed as common property, the first crucial step is to identify the nature of the disputed area. So you need to ask yourself, is this area truly intended to be for my benefit, or is it supposed to be for the collective benefit of all residents as common property? Some questions that you will need to ask along the way are also, what exactly is the space? Where is it located? Is it accessible from common corridors, car park entrances, or is the access private? And how has it been used since vacant possession, if it has been accessed by residents? So for recovery, consistent common access strengthens the argument that the disputed area has always been or was intended to be common property. Whereas for defense, you demonstrate restricted or private access, showing that it was never truly common. And then there's also the conduct of the MC or the JMB. So has this ever been included in the maintenance schedule? Was it insured? Was it patrolled? Was it repaired or lead as part of the common fund? So things like that would come into play. And then from the developers or disputed parcel owners' perspective, the same questions apply, but the aim is quite different. You want to show that the space was never intended to be used communally, that it was fenced off, separately accessed, and that any communal use, if occurred, was temporary, unauthorized, and that you have been footing the maintenance charges for these areas. So those are some of the things when it comes to identifying the nature of the disputed area. So once you've identified the specific area, the next thing is to review statutory and contractual documents. Now, this is your paper trail audit, where you meticulously examine what was legally intended, approved, and promised at each stage of the development. Now, these documents form the backbone of your case, whether you're initiating a claim or defending one. Now, at the planning and development stage, you have documents such as the planning permission, the development order, the approved layout plans, and the building plans. Here, you'll identify the initial intended use of the area approved by the local authority. So for recovery of common property, you'd want to show that the DO and the approved plans designate these areas as common property, and the developer or whoever the subsequent party later deviated from this by amending it unilaterally, for example. For defense, of course, you demonstrate the opposite. So you'd show that these early planning documents consistently have categorized these areas as a parcel or an accessory parcel, therefore it does not amount to a common property. And then you also have the developer's submissions for title and stratification. So here you have your cipher submissions, you have your proposed strata plan, you also have your strata title issuance, the certified strata plan, and the strata title itself. So the crucial question here is, of course, is the space clearly labeled as a parcel, accessory parcel, or common property? Now, for recovery, even if a strata title exists showing that it is an accessory parcel or a parcel, you can still argue that if it is defeasible, if it is obtained via fraud or insufficient void instruments, as we will discuss later in the case laws. And for defense, the certified strata plan and strata titles are often your strongest evidence. So you'd stress that your registered title is indefeasible, unless, of course, a strong legal exception is then proven. And then you also have your legal instruments creating the owner's rights. So then you also have your legal instruments. These are your core agreements, such as your SPA and your DMCs. So you need to determine, based on the SPAs, what were the contractual rights that were promised to the purchasers, what definitions were used for common property, specifically whether the disputed area was carved out of the meaning of common property in these documents, and what was the understanding of both the developer and the purchaser from the outset. And then you also have your promotional and representational materials, your brochures, your websites, the marketing videos, your contents. And then again, here you're asking the same questions. What was your understanding as a purchaser, and what was the representations made by the developer? And if you're defending, and then again, the same questions apply to you, what was your intention in the representations made? Now, beyond this official paper trail, you will also need to gather factual and evidential support from the ground, as this would then provide a real-world perspective. So we have things like photographs and CCTV footage. This would provide visual proof of how the area is used. So for recovery, you'd seek evidence of shared amenities within the disputed area, so like general public access, signage indicating common use, things like that. And for defense, you look for footage showing restricted access, private operations or clear signage denoting private ownership. You also have your maintenance record and invoices. So again, as I mentioned earlier, so for recovery, records of cleaning, repairs, landscaping, security services paid by the JMB can show that the collective has been maintaining the area. So it would strengthen the argument that it was meant to be a common property. Now for defense, you'd present records of the private owner or developer consistently footing these bills, implying private responsibility and ownership. And then the next is you will have to obtain expert opinion. So now recovering property or defending a claim is definitely not a DIY task. So ideally, you should complement this documentary and factual evidence with expert opinion. One expert you could consider getting is a registered land surveyor. So they come in with the definitive technical input, and you would need to get the advice of experienced lawyers. And in this case, it would be people like us, because we will advise on your statutory rights, what the law says you're entitled to, or what the obligations you might have. Also, they will highlight to you the past litigation strands and guide you with the evidentiary standards, what kind of proof the court will accept and how to present it effectively. Now, once you've done all of that meticulous preparation and you've gone through to that stage, the investigation, the paper trail, the factual evidence, and you've gotten your expert opinion, then the path to resolving these disputes often through civil legal suit. Now, this is where you have to really engage a lawyer and seek for formal redress through the legal system. So the civil courts are the appropriate venues for disputes like this, and they have the power to order the recovery of property, issue declarations about the status of the disputed area, order for cancellation of titles where necessary, or award compensation if appropriate. The reliefs that may be sought, or what the court can actually grant you, includes declaration that the area is or is not a common property, order to rectify strata rule or cancel title issued without authority if need be, and damages or compensation for unlawful deprivation of income derived from the common property. So those are some of the reliefs that can be sought. Now, this outlines the full spectrum of steps involved in navigating common property disputes. It's challenging but often necessary to protect the rights and interests of the people who are involved. Okay, so now having looked at the overview of the steps, of course, the entire process can take years, but having summarized it in this short 5 slides and having looked at the overview of the steps to recover common property or defend claims against the recovery of common property, we will now highlight some of the key evidence that would be required from your end, whether you are on the side of the JMB or MC or the developer. Now, think of this as compiling a comprehensive timeline of documents and facts that will tell the complete story of the property, broken down into 3 key stages of a development's life cycle from its very inception to its current reality. So we'll start with the pre-development or planning stage. Now, this is where the initial vision for the project takes shape and the developer gets official permissions. So the documents here are pretty vital for understanding the project's foundational intent. So what are the key documents here? We have things like authority approvals, planning permission, and development order. So this would have information like the areas that were meant to be common property. So if your dispute is about car parks, then it will mention the number of car parks that is supposed to be provided and how many visitor car parks you're supposed to provide, for instance. And then you have your layout plan. So this will give you a general layout of the entire development. Then you also have your approved building plan. So these are the detailed architectural and structural drawing, and they'll show you exactly what was approved to be built. And it is quite important to show access to the disputed areas and whether there were any common amenities within the disputed areas. And then you have your cipher submissions and your proposed strata plan. So these are the formal submissions for the strata plan approval submitted by the developer, and this will help in establishing the early intention. Then we move on to the next part, which is the sale and marketing stage. So this is where the developer communicates their vision to potential buyers, so creating certain expectations and entering into contracts. Now, the documents from this stage are all about representations and agreements. Now, this stage captures what was promised and legally agreed upon with the initial purchases. And these are the documents and representations that would have influenced the buyer's decision. The key documents here would be sale and purchase agreements, your marketing brochures and promotional materials, and you have your developer's website, online listing, floor plans, your booking form and purchase packages, things like that. Okay, and then post-development, you would have the legal formalization of the titles as well as the ongoing operations and any disputes that arise after the building is complete and occupied. Now, these documents represent what we would call the reality on the ground and the formal legal status. Now, the key documents here would be, for example, your certified strata plan. Now, this is the approved and legally binding plan for the strata subdivision. It's crucial because it will precisely define what is the parcel, the accessory parcel, and the common property. For recovery, you might challenge its validity if it conflicts with the initial documents. For defense, this could again be your primary shield if the disputed area is clearly defined as an accessory parcel or parcel and not a common property. And then you have your strata title. This is the document confirming ownership of a specific parcel or accessory parcel. While generally indefeasible, meaning hard to overturn, it's not absolute. So for recovery, you'd argue that it's defeasible because it was obtained by fraud or insufficient or void instrument. Now, for defense, you'd rely on your registered indefeasible title unless one of the exceptions again can be shown. And then you have things like your audit reports or accounts. Now, these are the financial records of the developer or MC. For recovery, audit reports might show that the disputed area was not accounted for as stock in trade by the developer, implying that it was intended as common property. Then, of course, you'll have your rental agreements, tenancy, licenses. This will provide direct evidence of commercial use of the disputed area. Photographic evidence is also always quite important because you can show visual proof of usage. Those are some of the key evidence or documents that will have to be complied along the way. Even though it seems as if that there's not much, compiling this can take many months. And if you're only disputing it way later on in the project, this entire thing can be very time consuming and troublesome because sometimes we may not be able to locate all the documents. Then now we will move on to understand some of the key arguments which are often raised by the JMB or Management Corporation in a claim for recovery of common property, and conversely by a developer and owner in a claim, defend against a claim for common property. To discuss this part, we will take a look at some of the Malaysian case laws, and this case will illustrate how the legal principles we've just discussed are applied in real-world disputes. Okay, we'll start off with the first case, Malaysia Land Properties Chandran Berhad against Waldorf and Windsor JMB. So I'll just start off with the brief facts. Malaysia Land Properties or Mayland was the developer of the Waldorf and Windsor Tower Service Apartment, high-rise mixed commercial development in Kuala Lumpur. The development included 2 towers and a shared podium block housing various facilities. Now, the core of the dispute was the entire 7th floor of the podium, referred to as Area A. This floor comprised of 89 car park bays, 9 retail units, and other areas that were marketed as luxury communal facilities such as karaoke room, gym, and a landscape garden. Now, crucially, at the time of the development approvals between 2001 to 2003, Area A was designated for common facilities and not for commercial sale. The building plans for the 7th floor did not provide for any commercial area. However, after the purchasers took vacant possession, the developer Mayland unilaterally applied for strata titles that included Area A as its own parcel. They went a step further and later sold parts of it to third parties. Now, the JMB, which was formed after the handover of the development, discovered this reclassification. And so they subsequently filed a suit claiming that the entire 7th floor was in fact common property and that Mayland's strata title to it was not valid. Okay, the JMB presented a pretty strong case emphasizing the developer's original intent and the nature of the space. They argued that the submission drawings showed Area A contained facilities common to residents such as library, nursery, management office, lift lobbies, and walkways. And this, at that time, were the classic common facilities under the BCPA definition. And a key piece of evidence was the sales brochure and the SPA itself, which identified a karaoke room, gym, landscape garden, and aerobic dancing room as common facilities. Now, the brochure clearly showed that all the common facilities were located on the 7th floor podium. This created a strong expectation among the purchasers. They also pointed out the absence of commercial infrastructure on the Area A. So there were no commercial electric meter installed for Area A, and this suggested that area was never intended for commercial use. Significantly, Area A was not recorded as a stock in trade or the developer's trade asset in their account. So the argument was, if the developer truly intended to sell it for commercial purposes, it should have been reflected as such in their financial records. And then furthermore, Area A also housed critical infrastructure like the sewerage, fire water piping, ventilation ducts, and the fire pump room. These are essential building services that must be accessible for maintenance, so again, strongly implying the common property status of the area. Now, finally, the JMB showed that the developer's own approved plans did not show commercial use on the 7th floor, and commercial zones were explicitly limited to the ground, first and second floors only. Now, Mayland or the developer's defense rested primarily on the validity of the planning and registration process and the concept of indivisibility of title. They argued that their submissions and as-built drawings for the 7th floor were approved by DBKL, JUPAM, and the Land Office without objection. They claimed that the strata plans were prepared by a licensed surveyor and the subdivision and title issuance complied with all the requirements of the Strata Title Act. Therefore, they said that the strata titles for the 7th floor were lawfully registered in the developer's name. Now, following this, Mayland also argued that their title was indivisible and that under the National Land Code, a registered title is generally conclusive evidence of ownership. Now, Mayland also argued that if there is any mistake in the plan, if it occurred, does not amount to fraud and thus should not render the title divisible. And they further asserted that there was no misrepresentation or fraud on their part, claiming no evidence showed that the JMB or parcel owners had existing rights over the disputed floor and or that they had relied on the sales brochure. Now, they attempted to clarify that the brochure and usage stating the building was commercial, not residential, and that the 7th floor was never meant for communal facilities. So the Court of Appeal did not agree with Mayland's arguments. It sided heavily with the JMB with these key findings. The court found that the entire 7th floor was initially planned and approved as a floor for common facilities, and the building plans did not provide for any commercial area on that floor. Crucially, if the 7th floor was intended for commercial sale, it should have been recorded as a stock in trade in Mayland's account. Their failure to produce such records invoked an adverse inference against them. The court also found that Mayland had wrongfully carved out the disputed area unilaterally without the JMB's consent and attempted to convert it to private property, and they did not have the right to do so. The sales brochures were also considered instrumental. The court found that the sales brochures clearly represented that the 7th floor as common facilities, and purchasers were led to believe that recreational facilities would be on that 7th floor. Now, ultimately, the court concluded that Mayland had obtained the strata title through fraud and misrepresentation perpetrated on the Land Office and JUPAM, and the authorities were wrongfully induced by the plan submitted by Mayland surveyor. And therefore, the court declared that Mayland's right, title, and interest in Area A or the 7th floor was not indivisible, and ownership of the common property then returned to the MC, but in this case, it was the JMB. Okay, so that is one case. Now we'll look into the second case, PG Center Stage JMB against Cherish Springs Chandran Berhad, a case which was handled by our firm and is very close to our heart. PG Center Stage is mixed-use development located in PJ Selangor. It's quite a large development consisting of about 789 Soho units, 352 service apartment, 158 retail shop lots, plus a multi-level podium that houses commercial space, car parks, rooftop areas, and landscaping. The core of the dispute arose because the developer registered some of the common areas as accessory parcels to rather small parcels or smaller units. For example, here a massive number of car park was attached to a tiny 301 Soho unit. The developer then sold these accessory parcels to the second defendant, a company related to the developer. Now, to further complicate the matter, the second defendant used these properties to secure loans from two financial institutions. They even assigned the tenancy income proceeds from these areas to the bank as security. Now, the JMB's argument was that the disputed area were never validly alienated. Their registration and subsequent sale breached the BCPA, the original building plans and planning conditions. They contended that these transactions were a sham and a fraudulent scheme designed to deprive purchasers of their rightful common property. The JMB's first and foundational argument was that the statutory definition of common property prevails. They argued that the disputed areas clearly fall under the broad definition of common property as outlined in the BCPA, which has now been superseded by the SMA. This statutory definition covers a wide area of shared spaces. Now, building on that, the JMB also asserted that there were accessory parcels that were unlawfully created and used. Specifically, the 342 car park bays and 7 basement areas were registered as accessory parcel to a tiny, small Soho unit. Now, the JMB argued that it was conceivable for such disproportionate area to be used or intended to be used in conjunction with that small parcel as required under the BCPA and the STA. And then they also pointed out that these car parks areas were not in any of the building plans as private accessory parcel. And this indicates that their later designation as APs was a deviation from the earlier approved plans. For the rooftops and level 6 rooftop and level 14 rooftop, the JMB's evidence showed that the approved building plans only designated this as RC rooftop with no provision for accessory parcels for private ownership. Now, beyond these plans, the developers' marketing brochures explicitly promoted this as shared facilities, advertising a gym, a pool, jacuzzi for all parcel owners. Now, this created a clear expectations for the purchasers. And also, of course, these areas contained inherent common property elements such as stairs, lifts, lobbies, tanks, and utility rooms. Now, additionally, there was also evidence to show that in reality, these areas were maintained by the JMB and that the developer or the related company did not quite make the payment as required. Further, these areas also were not recorded as stock in trade or developers' assets in their accounts, unlike the actual commercial units. Okay, so the JMB emphasized that the unilateral actions taken by the developer to apply for strata titles and amending the building plans to privatize these common areas without consent from the purchasers violated the purchasers' rights and expectations formed at the point of sale. The developer and the related company, they presented several arguments. The first is the registered ownership is valid. They claimed that all the disputed areas were validly registered as accessory parcel, that they relied on the issued strata titles, asserting that these titles were legally sound. They also argued that the commercial SPAs were valid, that the second defendant acquired the disputed parcels through a valid SPA, and that the purchase price, or for example here, the consideration was there for the agreement to be valid. And the amended building plan, so the developer also relied heavily on the local authorities' amended plan to justify the registrations of these areas under specific parcels. So they were essentially arguing that the approvals legitimized their actions. Okay, first at High Court, after a thorough review and of all the evidence before the court, overwhelmingly sided with the JMB. So some of the findings of the court is that the statutory definition prevails. The court firmly reiterated that the common property definition in the BCPA is broad and mandatory, and it overrides any contradictory clauses in SPAs or unilateral acts by the developer. Misuse of accessory parcel, the court found that registering grossly disproportionate accessory parcel was unlawful, and these areas could not be possibly used in conjunction with the main parcel. The title divisibility, fraud, and void instruments. So the court also declared that the developer's registered title was divisible on multiple grounds of breaches of the NLC, one of it being that the developer committed actual fraud by dishonestly depriving purchasers of their common property rights, especially through unilateral amendments after sales has concluded. So then the court found that the developer's breaches of these acts regarding the independent dealing of accessory parcels rendered the instrument of registration such as the strata title void. And the court went further by lifting the corporate veil of the related company involved. So it found that they were effectively the alter ego of the developer's family, and that the transactions between them were sham arrangements designed to defraud purchasers. The court also granted an extensive list of reliefs, including declarations that the disputed areas were common property, cancellation of the developer's strata title, order to deliver possession, order for the related companies to pay all the income and rent collected from the common property to the JMB, and plus an assessment of damages for the income that has already been lost. This case went up on appeal quite recently, and the Court of Appeal has upheld the High Court's decision. So the next case where recovery of common property was also allowed is the case of Ideal Advantage Chandran Berhad against Palm Spring. Brief facts: Palm Spring condominium is located in Kota Damansara. It's also a relatively large development consisting of about 2180 residential units. Under the development order issued by MBPJ, the developer here was required to provide a minimum of 2,000 plus car parks. Now, this was based on a formula of 1 car park per unit plus an additional 10% for visitors. The first defendant, Ideal Advantage, was a company that entered into 45 sale and purchase agreements with the developer for the purchase of 45 residential units. Now, however, this SPAs also included the sale of 439 accessory car parcels. Following this acquisition, Ideal Advantage then proceeded to rent out 394 of these car parks independently to third parties, essentially running a commercial car park business. Now, at the heart of the challenge, the management corporation, plaintiff strongly argued that the validity of the transfer of these 3 car park bays to the first defendant was unlawful. The MC's primary allegations were that the car parks were in fact part of common property and were specifically meant for visitors as per the development order. The SPAs between the D1 and D2 were a sham arrangement, and crucially, the MC argued that the car parks were not truly accessory parcels because they were not used in conjunction with the corresponding residential units that they were supposedly attached to. Instead, they were being used independently for commercial gain. The primary contention was that the 394 car park bays were not used in conjunction with the main unit. D1 was renting them out independently and commercially to unrelated third parties, and the MC argued that this conduct breached several sections, being Section 4, 34 sub 2, 69 of the Strata Titles Act. The MC also specifically contended that the term dealt with includes rental and tenancy. So they relied on the specific provisions from the NLC, where dealing is broadly defined, and sections 205, 223 to 224 of the NLC includes tenancy. So they argued that the NLC definition is imported into the STA, and therefore renting out these car parks independently constituted a prohibited dealing. Now, the MC also alleged that the SPAs between the first and second defendants were not bona fide and that they were sham arrangements intended to defeat statutory provisions given the close relationship between the two companies. And finally, they also highlighted the breach of development order. Now, under the development order, the developer was required to provide a specific breakdown of car parks, including 218 bays for visitors. By selling all of these 394 to the first defendant for commercial rental, the developer effectively breached the DO, depriving the MC of control over visitor car park bays. Now, the developer raised several counter arguments. They claimed to be in compliance with the development order. They argued that the requirement was to provide 2,398 car parks, and they have provided more than that in terms of number. They asserted also that there were no restriction on the number of car parks that could be sold to one unit purchaser, and they argued that the developer had the right to sell 394 car park bays to the first defendant. Now, critically, the first and second defendants argued that the tenancy does not constitute dealing under the STA. They maintained that dealing in the NLC context refers to registrable dealings, and since a tenancy is not registrable, it should not violate the sections under the STA. They also alleged unjust enrichment by the MC, and they accused the MC of gaining excess car parks when they are only entitled to 218. The Court of Appeal then affirmed the High Court's decision here, and they make some critical findings. So the court firmly held that the 394 accessory parcels were indeed not used in conjunction with the main units. Under the relevant sections of the STA, an accessory parcel must not be dealt with independently of the main parcel and must be used or intended to be used in conjunction with it. The court found that the first developer had acquired the 394 accessory parcels not for use with the 45 units, but with the clear intention of commercially renting them out as part of a standalone business, and this violated the purpose of the use in conjunction with. The court also clarified that the dealing includes tenancy. Dealing under the NLC includes tenancy, and this definition is indeed imported into the STA. Therefore, renting out accessory car parks independently of the main parcel is a prohibited dealing under the STA. And the court then found that the sale of the 394 car parks to D1 violated the STA, the development order, the planning law, and was thus rendered null and void by reason of illegality. The SPAs were found to be unlawful and void because of the intention to defeat the provisions of the STA. Crucially, the court also held that since the instrument of dealing was illegal and in contravention of the relevant laws, it fell under the category of being an insufficient or void instrument, and therefore the title was defeasible. And as a direct consequence of being deemed illegal, the 394 car park bays then reverted to common property, falling under the management of the plaintiff. So the first three cases that we have discussed, more or less the court allowed the recovery of common property. Now we will look at two other cases which have a bit more different or have mixed outcomes. The next case we will look at is 2 square and 3 2 square. In this case, the court directly addressed the used in conjunction with principle from a different angle than idle advantage. So the brief facts are this: in 3 2 square, okay, 3 2 square is a commercial strata development located in Petaling Jaya. So right off the bat, it was a commercial development. So it was a development that was commercial in nature. The project was developed by 3 2 square. The development includes various commercial parcels. Here, all the car park base was designated as an accessory parcel to one penthouse. Now, the developer retained both this penthouse and all these car park accessory parcels as its investment properties. These car park bays were then subsequently used by the defendant to run a commercial car park business. Again, on the surface, it may seem or sound like idle advantage, the only difference being that idle advantage was residential and 3 2 square is commercial. So the MC's arguments were pretty straightforward. They contended that the accessorization of all this car park bays to one penthouse was a breach of the STA, that they were being used, again, similarly, independently of the penthouse and not in conjunction with the penthouse as would be required for an accessory parcel. And here the defendant was clearly running a car park business as an independent commercial venture, and therefore by relying on previous authorities, they argued that the commercialization of the car park in this manner, particularly if not used in conjunction with the main parcel, is not allowed under the law and should render the title divisible. And the developer's argument was that they had lawfully retained ownership of their land and had validly subdivided the car parks as accessory parcels to the penthouse. They argued that the penthouse itself served as the management office. So this meant that the car parks were used in conjunction with the main parcel because the main parcel's function was directly related to managing those car parks. They also argued that there was no dealing because the car parks were never sold or transferred independently to other parties, and the developer retained ownership of its land and subdivided it. And therefore, the MC's attempt to invalidate the strata plan and claim ownership was beyond its jurisdiction and amounted to an unconstitutional deprivation of their property. And the developer also argued that the car parks were lawfully designed as accessory parcel in the approved strata plan. So this established lawful ownership and compliance with the initial titling process itself. And their strongest argument was that the penthouse unit indeed served as the car park management office. So in their view, the car parks were still being used in conjunction with the main parcel, as the main parcel's very purpose was to actually manage the car park business. So there was no dealing and it was used. And the main difference here, as we have highlighted earlier, was the commercial function of the main parcel itself. Now, the High Court here, they accepted the developer's argument that the penthouse held a commercial title and that its use as a car park management office was indeed integral to the car park business. And therefore, the car park parcels, right, were not used independently, but genuinely in conjunction with the main parcel being the penthouse. And the court concluded that based on this functional connection, the usage complied with the relevant sections of the STA, and therefore there was no breach of the used in conjunction with requirement, and therefore these car parks were not common property. Now, critically here, the court's decision was not really a blanket rejection of idle advantage, but more of a distinction based on specific facts. So unlike the residential units in idle advantage, the penthouse here was commercial in nature and was serving the excess car parks as management office. And the plaintiff also in this case failed to prove that the car park business was operated separately or independently of the main parcel. So this evidence showed the functional link. So it would appear that the courts seem to distinguish between commercial and residential units. So while commercialization of accessory parcels is generally a breach, accessory parcels to residential units is generally a breach, it might be permissible if the parcel itself has a legitimate commercial function. that is directly tied to and operates in conjunction with the use of those accessory parcels. Again, this can be a bit complicated and the arguments may vary, but this is how the two case laws have decided on similar facts, but nitty-gritty small differences. Now we will look at the final case of target term against Waldorf and Windsor Management Corporation. Now this case again revisits and clarifies some points from idle advantage. The background facts is the developer, again, is Malaysia Land Properties, the same developer as the earlier case that we saw, Mayland. In 2009, Mayland sold apartments, one apartment unit, along with a massive 420 car park lots to a related company, Target Term. Now, out of this, 414 were specifically registered as accessory parcels to that main unit. They then proceeded to operate a commercial parking business. So when the management corporation billed Target Term for over 850,000 in maintenance charges and sinking fund, Target Term then sued the MC and they sought a declaration that these charges were null and void, claiming that they were self-maintaining the car park units. In response, they counterclaimed and argued that the SPA between the Target Term and Mayland was unlawful. The car parks were in fact common property. Then the MC's arguments were that there was a clear contravention of the STA that prohibits accessory parcels from being dealt with independently of the main parcel, that the letting of these car parks for commercial use constituted an independent dealing, and that the car parks were not used in conjunction with the main parcel. Then the MC concluded that the 414 car parks lost their status as accessory parcels and should revert to common property. The developer then raised these arguments. So their main point was that the car park users were mere licensees and not tenants. They argued that there was no transfer of exclusive possession to the car parks to the car park users, which is the hallmark of a tenancy. So therefore, they contended that this commercial use not constitute a dealing which was prohibited by the STA, and this was a direct challenge to the idle advantage interpretation of dealing. They also argued that there was no breach of the development order, as the development order did not impose specific car park allocations separating resident from visitor base, and they emphasized that the certified strata plan explicitly identified the 400 park base as accessory parcel and that this should be conclusive. And consequently, the SPA was valid and the Target Term held a lawful title. Now the Court of Appeal, so the court unanimously allowed Target Terms and the developers appeal, and this was the findings of the court. So the court here stated that the use by license and not tenants, the court made a very clear distinction. It found that customers have no exclusive possession of the car park lots and their parking use was merely a license. And there was no dealing under Section 34 and 69 of the STA because it was a license and not a tenancy, which grants exclusive possession. The court held that allowing a customer to use the car park lot did not amount to a dealing in the accessory parcel as prohibited under the STA. And they explicitly also held that the difference between dealing in the sense between tenancy and a license. And the judgment specifically said that because the act of letting out a car park unit as part of a business merely amounts to a license to the car park customer to use a unit of car park, it does not amount to an act of dealing in the accessory parcels comprising the car park units. Now, for this reason, there was no contravention of the prohibition against independent dealing of accessory parcels contained in the STA. The court explained here things that dealing means things like sale, lease, or rental, where you give someone exclusive possession of the property. And here there was no exclusive possession. It was merely license. You come in to park on an hourly or a daily basis and you don't get any exclusive possession, and therefore it is a license. And because it is a license and it does not amount to a dealing, right? The court then held that the 414 car park parcels did not then amount to a common property. So there was also no DO breach, and therefore there no breach of the development order and the planning permissions, and therefore Target Term won the appeal. Now, having looked at these cases, we're just going to go back a bit and compare this because there are a bit of a mixed outcome in all of these cases. In contrast to PJ Center Stage, Target Term, in contrast to PJ Center Stage, the court in Target Term concluded that there was no contravention of the development orders in Target Term, and therefore the car park base were not common property. So the judgment in Target Term summarized their key findings quite clearly in the sense that because the act of letting out amounts to a license, it does not amount to an act of dealing. and that it also noted that there was no contravention of the development orders that had been issued for the development of that building. As a consequence itself, the SPA was not illegal or void. Now, in PG Center Stage, the approved building plans and amended building plans clearly showed that they were meant to be, the rooftops, for example, were meant to be rooftops, and they did not indicate that they had been subdivided as accessory parcels. So those are some of the differences. And physically, the rooftop contained various common property elements such as stairs, lifts, lobbies, electricity areas, and they featured some essential common properties like the stairs, swimming pool itself, and things like that. So the court were able to draw a distinction between PG Center Stage and target term. Okay, so now as we reflect on these cases, you will see how they tie directly back to our earlier slides on the importance of identifying the disputed area, reviewing documents, gathering evidence, and of course, preparing a solid case strategy. So what these decisions have consistently demonstrated is that whether you are the JMB or the MC or the developer, everything hinges on the evidence that you have. So it comes back to paper trail, your building plans, your planning permissions, development orders, sales brochures, SPAs, etc. Every document matters, and beyond the paperwork, the factual context of how the area is used, maintained, accessed, represented to owners and purchasers. So there may be contradictions between the documents and the evidence of the factual use, and therefore you will want to engage a good lawyer who can take these documents and evidence and organize them coherently and persuade the client with clarity as to what your case is. Because in court, of course, how the case is presented, how the legal principles are framed, argued, inconsistency or unlawful conduct are revealed, past precedents, applied, distinguished, and the facts, all of it will matter when it comes to the individual case specifically. So that would be all that we'll be covering for today. We will now go on to answer some of the questions. Okay, so that we have a question that if a strata title has already been issued and registered in the developer's name, can the JMB or MC still reclaim that area as common property? Now, while Section 340 of the NLC provides for indefeasibility of title, it's not absolute. So courts have held that indefeasibility may still be set aside where there is fraud, misrepresentations, or registrations obtained in breach of statutory duties. Now, in common property disputes, courts do not stop at the registered title. They examine the entire factual matrix, as we have seen in some of the cases such as PG Center Stage. So they look at things like the approved layout and strata plans, development orders, planning conditions, marketing materials, SPAs, and the statutory definitions of common property under the STA, SMA, and if the project development is older than sometimes even the BCPA, the actual use and treatment of the area by the developer, proprietor, and the JMB. So again, cases like PG Center Stage has shown that even if where there are titles issued, courts may still reclassify an area as common property where the underlying process is tainted and inconsistent with law. There's one question: if a JMB discovers that a rooftop or lobby has been registered as a necessary parcel and sold off, what steps should they take? So first, of course, you will have to compile all the relevant documents, as we have mentioned earlier, all your key evidence, and then you engage maybe a surveyor, or best is you come to us with your documents and we will more or less assess whether it was meant to be common property and then advise you on steps on how to recover it. We have run out of time. You can definitely contact us directly if you have any specific question regarding your development, and we give free 30 minutes free consultation, and we will be able to assist you with whatever questions you have if you can reach out to us directly. Okay, I will pass the floor back to my colleague Amir.
Thank you, Kirba, for speaking with us today. Now, before we conclude today's session, I do have a few announcements to make on behalf of the firm. First, do please join us again for our upcoming talks. We will have a talk on the 18th of June, which is on understanding your options under Sharia estate planning. This will be conducted by our Miss Anis and Miss Mira. We also will have a talk on the 25th of June, which is on crypto and anti-money laundering risks, trends in Malaysia, by Miss Agalia and Miss Kirtika. Secondly, as always, we have a feedback form for today's session. So please do let us know what you thought of our talk. The link to the form will be posted in the chat. Next, you can also follow or like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. Fourthly, as mentioned by Ms. Kirba, if you would like to speak with any of our lawyers, we do offer a complimentary consultation of up to 30 minutes over the phone or over video conference. To do, please fill in the form on our website. The link also is posted in the chat box. And that is all for today's talk. Thank you very much to all our guests for joining us. As always, we hope you found today's session informative and useful. Thank you again, and see you at our next talk.